Good morning, Rebels. This is Jen, the Liberty Lion. Today I want to talk about jurisdiction and how important it is, and how you won't hear hardly anyone out there talking about the Constitution and its limited jurisdiction. I've showed you a definition from, I believe it was Black's Law Dictionary, that stated the definition of federal government does not include the people of the states. It includes the states and its relationship with each other together as a union, but does not include the individual people of those states. I've also explained to you how laws and the right to make laws are attached to land. So you have your land and you have the right to make some laws over your land. And I have my land and I have the right to make some laws over my land. The government has its land and the right to make laws over its land. The states have a right to make laws for the state land, and the federal government has the right to make law for the federal lands. The Constitution lists two lands that it has the right to make laws for. Those are in Article 1, Section 8, Clause 17, which most people you'll find do not talk about, do not understand, and you won't see it written in too many books. And you'll actually read a lot of stuff that goes against the idea of what Article 1, Section 8, Clause 17 says. Article 1, Section 8, Clause 17 states that the federal government has two jurisdictions on two types of lands. It has exclusive jurisdiction, or the right to make all laws, over the seat of government, Washington, D.C., the District of Columbia, and then it has like authority over the places purchased. And those are the military posts. The federal government was not given any right to buy any other kind of land, and it was not given the right to accept donations of lands. It was only given the right to make laws over the seat of government, and it was given the right to make like types laws that are listed in the Constitution, or like authority over places purchased. Here in the records of the Federal Convention, page 620, September 14th, McHenry is talking about how they want a college at the seat of government. And he moved to authorize Congress to establish a university to which, and the honors and emoluments of which, all persons may be admitted without any distinction of religion whatever. So basically he's saying that they want a college that will accept all people. And he wants it at the seat of government, and he wants Congress to authorize it. Congress enabled to erect such an institution in the place of the general government. So at the seat of government, the seat, Washington, D.C., District of Columbia. That is the land which Congress and Congress assembled has the right to make laws for, without interference from the state. That's what exclusive jurisdiction is, that the states have no right to interfere with the federal government's lawmaking power. The reason why they had to put this in here is because the states are supposed to control the federal government. They have power over the federal government. They can make or break the federal government, except at the seat. The seat of government is where the federal government has exclusive jurisdiction. Like authority over the places purchased, which are the military posts, the authority could be reserved by the states for some purposes. So the states had the right to make laws over the federal lands or to apply their state laws over the federal people on the federal lands for certain purposes when those states reserved their rights over those lands. So we have exclusive legislative jurisdiction, concurrent legislative jurisdiction, partial legislative jurisdiction. So exclusive is what they have at the seat of government. Concurrent, partial, proprietorial, and unknown are what they have over the federal lands in the states, depending on what rights the states reserved for themselves over those federal lands. Exclusive jurisdiction, thus Congress to possess exclusive jurisdiction, because it's an act by Congress at the seat of government, and at the seat of government is exclusive jurisdiction. The Congress has exclusive jurisdiction, which is lex situs, or the law of the land. The states have lex situs, and then their state government, law of the land. The people have their own law, often called common law or customs, custom law, custom, which the people have. So people have the right to make their own customs. The states have the right to have state laws, and the federal government has the right to have federal laws. Each one can make laws over their own land. But the people of the state have to comply with the state laws, and the states have to comply with the federal laws, but only when it comes to the federal lands. States possess sovereign authority over the federal lands except the seat of government, because the states agreed when they agreed to the Constitution to allow the federal government to have exclusive legislative jurisdiction over the seat of government, Washington, D.C. But some states retain the right to make laws over the federal lands in the states. And usually these were only certain laws, such as issuing a summons or a warrant. So when a federal person, such as a military officer, comes off a military post and commits a crime and runs back to the military post, the state is saying that they have a right to go onto that military post and arrest that person. Some states didn't retain the right to arrest them, but only retained the right to go to the military post and drop the summons off to an MP, a military policeman, and have the military policeman arrest the person and bring him to the state people. So there were different types of jurisdictions or different types of rights that the states retained over the federal lands that are in their states. So Texas cannot have the right over federal lands in Tennessee, and Tennessee cannot have rights over federal lands in Texas, but Texas can have some rights over the federal lands in Texas. And this is true for all states, but the states did agree collectively to some things, such as their mutual defense, spelled with a C, not an S, for their mutual protection through the federal government. And usually you can find these in the state statute laws. So for example, you have a Republic of Texas Constitution, which was supposed to be over the independent citizens or civilians living in Texas who formed a government for themselves called Republic of Texas. And then you had the state of Texas, which was the relationship between the federal government and Texas, or Republic of Texas. How the state administered the laws on federal lands was done through the state of Texas Constitution. So the state of Texas Constitution is the constitution that helps aid the federal government and the state in administering each jurisdiction on federal lands. So states like Texas had rights over federal lands. The federal government does not have any rights off federal lands. There's nothing that says so much in the Constitution. There's nothing that says in the Constitution that the federal government has rights over states off federal lands, unless, of course, the states call the federal government for help in quelling an uprising or aiding in the peace during a riot, in which case the military will be given police powers temporarily so that they can send people home, basically, or make some arrests. They're not supposed to go around beating on people. They're not supposed to go around stealing property. They're supposed to, for example, move your car if it's in the way. They're supposed to be able to, let's say, take some wood out of your yard to build a barrier. Maybe they'll use your yard as a place to hold people or park their cars or something like that. And that's it. They have a right to take people to jail, and they must do so only with the force required to get done what they need to get done. So recently, there's another video posted on, I think, YouTube, of 3 police officers beating and beating and beating and kicking and punching a man who was already on the ground. Excessive force, of course. There's a lot of views, some of which state that if the man was resisting arrest, the police have a right to beat on him. But that's just not true. But getting back to jurisdiction, Congress to possess exclusive jurisdiction because the university was to be made. Let me take that off. The university was to be built in the place of the general government, and that's the seat. You can find this record at memory.loc.gov. It seems like for some people, no matter how much information, no matter how many facts I give to them, they just don't accept it. But that's okay. They will in time. They'll have no choice to. It'll become common knowledge and they won't be able to deny it. So here in the Federal Register, Volume 64, number 153, Tuesday, August 10th, 1999, Presidential Documents, page 43256. I believe this one was signed by Clinton. Says, acts of the national government, whether legislative, executive, or judicial in nature, that exceed the listed or enumerated or numbered powers, so limited, of that government under the Constitution, violate the principle of federalism established by the framers. And here it says the nature of our constitutional system encourages a healthy diversity in the public policies adopted by the people of the several states. That does not mean we the people, because it says we the people of the United States. Acts of the national government, whether legislative, executive, or judicial in nature, that exceed the limited powers of the government listed under the Constitution violate the principle of federalism established by the framers. And we've talked about this in other videos before also, that the federal powers are numbered, and that when a person goes to the seat of government to represent states collectively, they have to take an oath, and the oath limits what they can do. And when they do something outside the oath, they act without the power to perform the act. Some man cannot walk into your home and say, "I'm your father," and start acting as though he's your father. He has no power to do that. He has no power to act as a father when he is not. A person who takes an oath has no power to act outside the oath, because there's no power in the Constitution that allows it. So those acts are simply void. They're not even voidable in court, because they mean so little and they have so little value. They have no authority, that the courts don't even need to administer them or form an opinion of them, because they have no power. They have no authority. There's no jurisdiction. Here's a map of Texas from nationalatlas.gov. The website has since been taken down, said to have, by the government, expired. And on this map, it shows the federal areas in Texas. Department of Defense are the only constitutional federal areas. The Bureau of Reclamation is not federal. It's not constitutional, I should say. Fish and Wildlife Service Wilderness is not constitutional. Forest Service is not constitutional. And National Park Service is not constitutional. The only thing the Constitution is allowed to have lands for are for military purposes, to erect posts for defense. And it says that also in Article 1, Section 8, Clause 17. So I use this map where we have Fort Hood, Camp Swift, Camp Bullis, so on and so forth. Randolph Air Force Base, Fort Sam Houston, Brooks Air Force Base. These are the only areas that the federal government actually has a constitutional right to own, or to, in Texas, really just administer and hold, because Texas retained its sovereignty. When Texas tried to secede from the Union in the 1860s due to the Civil War, Lincoln called them rebel states, said that they were illegal, and used military force to take over their capitals and act outside the Constitution. An unconstitutional act without authority, which is void. So what they did when he did that is basically expanded the state of Texas to make it appear as though, even though it actually doesn't, make it appear as though the state of Texas includes the entire state. The state of Texas is the relationship between the federal areas and the Republic of Texas. The Texas Jurisprudence Book, 3rd edition, states that under statehood, the Republic of Texas never ceased to exist. And this is also found in the GSA manual. This is part of the GSA manual. This is the GSA manual that I show people. I've been showing it for a long time. And it says in here, the state of Texas are the federal areas because the Republic of Texas never gave up sovereignty. It retained its rights. You can read this for yourself. It's fairly easily found online. It's got a wealth of information in this small 20, 30, 40 page book. I encourage you to read it. Try to understand it. We also have 2 jurisdiction manuals, or reports actually, issued in 56 and 57 during the Eisenhower administration, where you can read about a lot of the views that I talk about on this channel. And in part 1, this is part 2, let's look at part 1. It gives you right up front in chapter 1 a simple like 1 page. Okay, this is chapter 1 outline of study. If you can read this 1 page, it says, it gives you a wealth of information. What it says is that the federal people wanted to use state resources, and the state said no. The federal people got mad, and they took it to the Supreme Court, and the Supreme Court agreed and said no. But this resulted in various contracts between the federal government and the states to pay the states to provide for things like education to the children living on the federal lands. With that money came stipulations which ended or resulted in us being where we are now, where we have the federal government telling our schools, state schools, that we created for ourselves, what we can and cannot do, what we can and cannot teach, all the vaccinations that the children must have, that the child must have a birth certificate, which is a legal name, placing them under the jurisdiction of the state of Texas or the state of Tennessee, which is federal jurisdiction, which those children are not supposed to be under federal jurisdiction unless they're the children that live on the federal lands. They're supposed to be under the jurisdiction of their parents and the state. Here's a case law. United States versus 1 Woodbury and Minot, page 76, where the United States own land situated within the limits of particular states. Now, in the Constitution, it states that the federal government may purchase lands from particular states in which to erect their military posts, and over which they have no cession of jurisdiction for objects either special or general. Little doubt exists that the rights and remedies in relation to it are usually the same as applied to other landholders within the states. This means on lands where the federal government was not ceded jurisdiction over those particular lands, they have no more jurisdiction over them than a regular person who holds lands. Recently, I saw an article that showed there was a large portion of land in Hawaii, and this is recent, that was donated to the federal government. This tells you a lot because those land donations come from people who have made money doing business and getting favors from the federal government. It's a monopoly, it's a scam, it's a scheme. So if a bank gets a bailout and the bank owner goes and buys 3,000 acres with that money and then donates it to the federal government, he has just enlarged the federal government after receiving a favor from the federal government. And this happens a lot because this is what Rockefeller did. He donated lands to the federal government. The Federal Reserve Bank sits on lands owned by Rockefeller. I believe that's the Manhattan Island Bank, where they have a treasury and an IRS, where they administer taxes and use of force to your legal fiction. And your legal fiction is created on a birth certificate, a legal document, and legal documents are fictions. We've talked about that. Making you a fiction. And if you're a fiction, you're no longer in nature, and therefore you're to be controlled because you're a creation or a creature. You're not a creature of nature, you're a creature of man. When you're a creature of man, you're not in nature and you're not controlled by nature and you don't have natural rights. You have the rights they allow you to have. Your legal fiction has a legal title, which may be your mortgage or your vehicles, so on and so forth, to which you don't actually own because fictions can't actually own anything. Recently, I heard someone say that the people who pull oil, the oil companies, the people who use oil to get money, that they don't own taxes. They don't owe taxes. They don't pay taxes. And it makes sense if you think about it because those oil companies are taking something directly from the earth. There's no taxes on gold and silver. The Constitution is a lawful document and it states gold and silver is lawful money. It does not state that gold and silver is a legal currency or a fiat paper currency or a contract. But that's what fiat money is. It's a contract. And it comes with stipulations. When you use it, you owe someone a portion of your yield. When you buy land with it, you owe someone a portion of your yield. When you get paid for it, paid it for work done that you go to work and you work for someone and you get paid in dollars, as part of that contract, you owe a portion of your labor as a legal fiction. You're supposed to have your own labor to yourself, for your family, because that is how you accumulate wealth. And your labor is a natural thing. And you should be paid in gold and silver for your labor. Otherwise, you have to pay some back. Use of the dollar means you have to pay some back of whatever you make. It's part of the contract. A contract is Title 26 among many other titles. So here was just another paper of the founders acknowledging that the jurisdiction extends to the federal government at the seat, and it is shared by the states and the federal government when the land is in the states. Okay, so like, share, subscribe, and I'll see you in the next video.